Hi there, and welcome back to module number 7 in creative real estate investing. So in module number 7, we're going to talk about deal structure and negotiating. But before we get into that, we've got a few other things we need to cover, such as the purchase and sale agreement, as well as conditions both in the conventional and the non-conventional manner. We'll also need to talk about waivers and fulfillment of contracts. Then we'll wrap up module 7 with deal structure and negotiating. So let's get started with purchase and sale agreement. So creative real estate is not always about getting the deal with the most creative terms. Sometimes it is simply just getting the deal. And in order to get the deal, you need to understand all the forms, the contracts, the clauses that you're going to be using so that you make sure you can act quickly, precisely, and legally, and be most effective as well, which is why I believe that we need to spend a little bit of time on some of these contracts. So what exactly is a purchase and sale agreement? Well, it's simply a contract. It's in common law legal systems. It's an agreement having a lawful object entered into voluntarily by two or more parties, each of whom intends to create one or more legal obligations between themselves. The elements of the contract are the offer, the acceptance by competent persons having legal capacity who exchange consideration to create a mutuality of obligation. A real tongue twister. So the capacity of parties. The parties must be legally competent to enter into a contract. So first of all, they must be of legal age. So 18 years of age, they would be deemed to be legally competent to enter into a contract. However, if their mental capacity is insufficient to be deemed legally competent, then you need to be aware of that as well. Next, it needs to be a legal object. In other words, the purpose of the contract must be lawful and not contravene any public policy. So, for example, a drug deal would be a perfect example where you've got some marijuana or some other illegal drug. It is a product. You can enter into a contract for one person to purchase the product from another person. Well, it's a contract, but it's not a legal contract because it's not for a legal purpose. So it has to be for a legal product, a legal purpose as well. Legal intention. So the parties must intend that their action creates a legally binding arrangement. In other words, you can't enter into a contract and with the full intention of not fulfilling that contract. If you do, then that can be deemed to be illegal and you could be forced to fulfill the contract, or you could be charged for entering into an improper contract as well. Consideration. Each party to a contract must receive something of value in exchange, not necessarily equal value, for the promises of that the other party makes. So it doesn't need to be money, and it doesn't need to be of equal value. For example, if I was to sell you a small piece of land that's worth $40,000, but I have no use for it, but you have an RV. And your RV, if I was to go out and buy the RV new, would probably cost me $40,000, $45,000. Your RV is in pretty good shape. You're not using it, so it doesn't have a whole lot of value to you. We could exchange those two articles. I sell you the land in exchange for the RV. We could also do it for as little as $1, as long as there is something to be exchanged. I can't just sell you something and receive nothing in return. There has to be consideration there. Mutual agreement. So the process of offer and acceptance necessary for the performance of a contract. Both have to mutually agree. In other words, if one person is not in agreement to sell and they're being forced or blackmailed, coerced some way, then that's not a legal binding contract. Genuine consent. Both parties must have all the facts needed to make a reasonable decision, and they must consent to it of their own free will. So, for example, if you have some knowledge about the property that the other individual is not aware of, or if you have knowledge that is going to affect the property adversely and you don't share that, then the contract could become null and void. So you need to be aware of that. Now, where do you get hold of a purchase and sale agreement or the contracts? Well, for the most part, realtors are regulated by their provincial or state body. So in Ontario, it's Ontario Real Estate Association. In Alberta, it would be Alberta Real Estate Association. And then there's, for the entire country, there's the Canadian Real Estate Association as well. Now, each of these bodies, that's the same thing in the U.S. market. Each state will have a governing body that will create all of the legal documents for the agents to use. Does it mean you have to use those? No. It just means that that's one source of contracts. You can go to a stationery store like Office Depot or Staples, and or even some of the bookstores, and you can get generic forms for purchase and sale, and you can make use of those as well. Your lawyer is actually able to buy and sell real estate like a real estate agent because they have that ability under the umbrella of being a lawyer. So they will have contracts readily available for themselves to use as well. And the bottom line is you could simply take a sheet of paper, a blank sheet of paper, and as long as you've got all of the parts of the contract that we just talked about earlier, such as the price, the address, the terms, and both signatures, then that piece of paper can act as a legal binding contract between two willing parties. Now, as a licensed real estate agent, I must use the forms approved by OREA, which is the Ontario Real Estate Association. If anybody were to approach me and ask me to represent them in the purchase or the sale of a property, I would have to use the forms that OREA produces. So, when can an agent use non-approved forms? Now, if you were to ask an agent, can they ever use non-approved forms? Their answer would most likely be no, you cannot. But the reality is, when presenting an offer written by the buyer or somebody else is the only time that a licensed real estate agent can use those forms. In other words, the agent themselves haven't filled out the forms. They haven't completed the forms. The buyer shows up, and if I'm the licensed agent, the buyer shows up, they've already got the purchase and sale agreement written out. They've written it using their own forms wherever they got them from. They hand it to me and they ask me to present it. At that point in time, I can present the offer. If they come to me though and ask for me to write up the offer, then I have to use the forms, in my case, the Ontario real estate forms. So when would be a good time to use non-approved forms? Well, if you're representing yourself and you're doing private deals, then there's no need to use regulated forms. You can use, as I said, as simple as a blank piece of paper and create your own. I don't recommend you do that, by the way. At least go to a stationery store, bookstore, and get some forms that have been created. Or you can go online to the internet and you can download lots of forms as well. However, I would suggest you do try and use some standard forms. So if, for example, you are in Ontario, if there's any way you could get hold of forms that have been approved by the Ontario Real Estate Association, then I would, as a private individual, try and make use of those. The problem is, or the challenge is, as an agent, I can't share those forms with you, nor can or should any other realtor share those forms with the general public. Those forms are only for the licensed realtors to make use of. And the reason I say that it would be good if you can to use those forms is that they're just going to be more standard. They will be structured better. They're the best structured forms that are out there, so they will greatly reduce the risk or the chances of you doing something incorrectly. All right, now, next question. I get this a lot, actually. Do real estate agents have to present all offers? Well, the short and quick answer is yes, we do. If anybody presents an offer to us, then we must present that offer to the seller of the property unless we have been given specific written instructions from the seller stating otherwise. So for example, let's say that the house or the property is listed for $400,000. The seller could tell me, do not present any offers to me unless they are over $350,000. So somebody presents an offer for $340,000. I'll simply state that it has not met the threshold for the buyer, or for the seller rather, therefore I'm not presenting that offer. Now I have to be prepared to prove to the buyer that I do have these written instructions. They can't just be verbal. So that's the only time that I'm, as a licensed agent, not required to deliver the offer. If there was nothing written stating otherwise, then yes, any offer that is presented needs to be presented to the seller. Now, this is something a lot of people don't realize, and actually a lot of realtors don't realize as well. So if you are the buyer, are you allowed to speak with the seller or present your offer directly to the seller when the property is listed with a real estate brokerage? And actually, yes, you are. But what will happen is many agents will say, no, you can't because it's listed on MLS. You have to go through the brokerage. Well, if it's listed on MLS or listed through a brokerage, they want you to go through the brokerage, and the brokerage is representing the seller. But there is nothing to prevent you from going directly to the seller to knock on the door, ask questions, present your offer. The seller may, and they have the right to say, no, I'm not talking to you, deal with my my real estate agent, real estate brokerage. But the bottom line is you are allowed to do that. But why would you want to do that? Well, in some cases, not all real estate agents are the most ethical out there. In some cases, they may defer presenting your offer because they think it's too low. But you want to have your offer presented anyways, and you want the seller to see the other terms that are inside the offer. But the agent refuses to do so. In a case like that, the proper channels, what I would suggest you do if you're having a challenge with the listing agent, the proper challenge is to talk to the listing agent's broker or manager. If you don't get anywhere there, then you can go directly to the seller of that property. And you could walk up, knock on the door and say, Mr. Seller, my name is so-and-so. I had written an offer, presented it to your agent to present to you. He refused to present it. I just wanted to make sure you got it in your hands. Now, you can do that. You cannot demand that the seller negotiate with you, though. So you can't force them to do anything else. If they invite you in and you sit down and you strike up a deal, then absolutely there's no problem negotiating if both willing parties are there. Now, very few, if any, real estate agents will knowingly allow you to do this because they're simply going to feel like they're losing control. And in some particular cases, rightly so, because sometimes the seller will talk too much or the buyer will talk too much, and things won't go the way that they should go. The seller could say something that could cause him to lose some value in the sale, or things could get heated and people get stubborn. There's all kinds of reasons why it's not necessarily a good thing to have the seller speaking directly to the buyer. But on the flip side, if you're doing it from an ethical position where you want to build a relationship, get to know the seller, understand the seller, why they're selling, see if they can't come up, discover some common ground in order to make the deal work, then it makes sense to meet with the seller. And this is the only way you're going to be able to do that, is to do an end run around the real estate agent, because again, most real estate agents will not allow you to meet directly with, or they will greatly discourage you from meeting directly with the seller. A lot of agents also feel insecure because if you do an end run around them, they think that they're going to lose their commissions. Well, they can't lose their commissions because they have entered into a contract, or the brokerage has entered into a contract with the seller. And regardless of if the seller sells the property on their own or whether you sell the property for them, the commission is still owed to the brokerage. So the agent's still going to get paid regardless. It's just in a lot of cases, it's the agent's lack of knowledge or their ignorance about what can be done. Their ignorance about the value of having two parties get to know each other to negotiate the deal. Yeah, so the bottom line is you can do it. I wouldn't suggest you do it without the agent's knowledge. I would always try and work through the agents first. Include the agents so that you don't go against the flow with respect to the agents. You want to work with them. All right, the most important sections for your success in the purchase and sale agreement. First of all, the deposit. How much do you have to put down? Now, it greatly depends on what it is you're buying. If you're buying a single family house, you can easily get away with $500 to $5,000 as your initial down payment. Legally, it only has to be as much as $1. Now, very few people, if any, will ever accept $1. When you get into the larger deals, even if you get into small multis like a sixplex or a 12-unit building, you can expect that deposit to grow exponentially as well. Most realtors, most sellers are going to expect a deposit of $5,000 to $10,000. When you get into even bigger deals, then it continues to grow in size as well. What you can do is, if you're trying to do it with as little as possible, say for example you want to do it with a $500 deposit, you could try a $500 deposit and then increase the size of that deposit later. Talk about that in a moment. Now, you also want to, you'll have the option of putting a deposit upon acceptance or a deposit herewith. The challenge with using the term herewith is that the moment the real estate brokerage receives your deposit, they usually have to deposit that into a trust account within 48 to 72 hours. Now, you could make an offer, and the offer could go back and forth between the two parties, and it could take a week before you get an offer that's mutually agreeable to both parties, or you could spend the whole week and not come to terms. In the meantime, they've taken your deposit and they had to deposit it in the bank account. That is a requirement. They cannot hold on to your check and just give that check back to you. Therefore, you may want to consider using the term upon acceptance. So when with the upon acceptance, you can go back and forth in negotiations for a week. If you don't come to terms, you don't have to give them a deposit. If you come to terms, that's when you give them the deposit, no matter how much it was you agreed. You give them the deposit, and then the listing brokerage will deposit it into their trust account. Now, if they want a bigger deposit, say for example you give them a $1,000 deposit and they want a $5,000 deposit. So you've made the offer, you've made it for $1,000. Upon acceptance, they counter your offer with price and other terms. One of the things that they counter, though, is that they want a bigger deposit. So they stroke out $1,000 and they put in $5,000. Well, what you can do is you can stroke out the $5,000, put it back to $1,000, and then you could write in an additional deposit of $4,000 upon removal of all conditions. You have no problem increasing the size of the deposit at that point in time, because once you remove all of the conditions that you put into it, you are now committed to buy that property anyhow. Irrevocability, should you keep it short or long? Well, what irrevocability simply means is that if I make an offer to the seller, I'm going to give the seller 24 hours to think about it and sign it back to me. If they take longer than 24 hours, then technically that deal becomes dead, null and void, and I can move on to other deals. If they accept the offer in the 24 hours, it's a done deal, subject to any conditions that I've put into it. If they counter back and they need to give me more time, one of the things they will change is the irrevocable date. So if I make it irrevocable till Saturday at noon, but they don't deal with it until Saturday morning, they may make it irrevocable from themselves until Sunday at noon. So that irrevocability date can go back and forth. The question is, do you give the person a short amount of time to think about it or a long amount of time? Well, if you sense that you're in a hot market and there's lots of buyers out there, then you're going to want to keep it short because you don't want other competition coming in and trying to bump your offer or get into a bidding war. Now, if the market is, if it's a buyer's market and there's lots of buyers out there and you're going in with low offers, you can give them a longer time to think about it because there's not as many buyers chasing that property. And there's less competition, so there's less fear. Plus, if somebody bumps you, there's lots of other opportunities out there as well. Completion date. If it's a single family home for your own personal residence, then completion date doesn't really matter. However, keep in mind that I would not use a Friday because quite often things can get moved or things happen and you can't close on the day that you expect to close. And the lawyers only work Monday to Friday. So if you run into a challenge on the Friday that you're trying to close on and they have to push it out, that means they're pushing it out to at least Monday. And in the meantime, you don't have a place to live potentially. So that's just something to keep in mind. If it is a rental property where there are rents being collected at the first of each month, what you want to do is you want to put a completion date in that first week, the 3rd to the 10th of the month. This way, the seller is responsible for collecting all of the rents for the month. And then what they have to do is they have to prorate it and give you some of that money back. So if you're buying it on the 10th and there's 30 days in the month, they have to give you 2/3 of the rents back. And that's done through the lawyer's office. So this way you don't have to worry about collecting rents on the day that you buy that property. If you close on the last day of the month or the very first day of the month, then the question is, well, who's collecting the rents? And all of a sudden you're just thrown into the mix here and you just bought the property and the Monday is the 1st and now you have to go out and collect rents from these people who don't know you from a hole in the ground. So it just makes it easier transition to do it anywhere from the 3rd to the 10th of the month. Rental items can be a bone of contention as well. So the seller is supposed to disclose all rental items in a property, and depending where you reside, different areas of the country have different trends. It used to be very big here in Ontario that you could even rent a furnace. Well, that stopped for many years. It's actually starting to pick up again. Hot water tanks are a big item though that you can rent, so you don't have to buy a hot water tank. It could be a water softener system in the house, could be a rental as well. So there's there's potential for different items to be rental items. They are supposed to disclose this when they list the property and when they market the property. If they fail to identify any rental items and you buy the property without these rental items being disclosed or identified, then the seller must pay out the rental contracts because you didn't buy a property with rental items from your perspective. All right, other important sections also, spousal consent. So if you're looking at a property and you're dealing with just one individual, where the male or female doesn't matter, and you get a sense that there was another partner in the mix, and it doesn't have to be opposite sex, it could be a same-sex partner as well. If you get a sense that there was another person involved in the living in this house, then you may need to dig a little bit deeper and get spousal consent. Because let's say, for example, a couple just broke up and spouse A is living in the house, spouse B has moved out, but just recently, just a couple weeks ago. And you can tell just by some of the items around the house that there used to be a second party in the house. So you ask if there's anybody else that they need to deal with, they may say no. You may want to pull the title on that property to see who's actually on title, because both spouses may be on title, in which case you need to have their consent as well. Also, even if they're not on title, but they've been living in the house for an extended period of time, they may fall under the common law rules, and they may be entitled to 50% of that house. Therefore, you need to make sure you've got their consent to sell the house as well. Then you've got the confirmation of acceptance. So when the deal has gone back and forth, basically the last person to accept all of the conditions in the offer has to sign a special space. It's usually on the signing page where all the signatures are collected. It's called confirmation of acceptance. And what this means is that it's sort of like the firing pistol at a race. This is when the time period begins. So if you've got 5 days for financing, it's going to be 5 days after acceptance of the offer. So the last person to accept all of the conditions will sign this, date it, and that's when the time period starts. Then you've got all of the schedules. Now usually in a single family home, there's usually only one schedule attached. Again, it depends on the jurisdictions. Some jurisdictions love to use multiple schedules. If you're dealing with a larger property, there could be multiple schedules as well. So this is where in Schedule A, you would put all of your conditions. Now, that's not necessarily the case because in some provinces, some states, the purchase and sale agreement itself may have conditions built into the purchase and sale agreement. In Ontario, any conditions we add, such as conditional upon inspection, financing, etc., these are all added in the Schedule A and attached to the purchase and sale agreement. If you want to include the profit and loss statements for the property, any surveys, environmental studies, these can all be included as Schedules B, C, D, etc. There's no real limit for it. Now, in your Schedule A, or for the conditions, there's 4 main conditions that you're going to want to have. It's not restricted to these, but these are the 4 main ones. There's your finance condition. So it's going to be subject to you being able to obtain financing for the property that you're happy with. Inspection of the property. And you'll see when I do an inspection, it's multiple inspections, the ability to do multiple inspections, because you may do an inspection of the property and decide, you know what, I want to take my electrician back in. I want to take the furnace technician in. So you want the opportunity to go in multiple times. Review of documents. Again, not so much applicable with single family homes. You may want to see the taxes, the heating costs, etc. However, when you're looking at multi-unit buildings, you want to see all of the related documents to that property. So you want to receive them in a very specified short period of time, and then give yourself time to review all those documents to make sure that they are accurately represented in the expenses. And especially if you're new to the game of investing, and especially with larger deals, a little bit more complicated, it's not just your straightforward single family home, you can have a very simple basic clause subject to your lawyer's review. So you can send it off to your lawyer, they can review it, give you a heads up to make sure it's good or not, or highlight something you need to look for or take care of. So now there's pages and pages of conditions that you can use. Each province, each state are going to have through their board all kinds of clauses that have been used. There's all kinds of clauses floating around out there already as well. This gentleman is a lawyer, and he's put on his website a lot of the condition clauses that are used in real estate. So if you're writing up your own purchase and sale agreement, you can go to this particular website, and there's lots of other websites out there as well that you can draw from. I, as a licensed realtor here in Ontario, I am not allowed to share with you the conditions that we as licensed realtors use in this province, and that's the same in any other province or state. They're not allowed to share those with the general public. So that's the basic nuts and bolts of a purchase and sale agreement. So again, if you have any questions, please feel free to email me and or ask the question during the live Q&A session. And I look forward to speaking with you in lesson number 2. Take care.